So as I say, welcome to the latest employment law update webinar from Moorcrofts. You're very welcome to join us today. We've got a packed agenda, as you can see. Lindsay's going to start off by talking about the fallout from the pandemic. We've seen some really interesting cases on sort of health and safety dismissals and unfair dismissal. Then I'm going to talk a little bit about flexible working, because that's probably the main announcement in terms of employment law that's been made. Then we're going to have a break, whether it's at 10:50, it might be a little bit earlier than that, but hopefully we'll have a break for 10 minutes to allow everyone to recharge their tea and coffee, or let that lockdown puppy out into the garden for a walk or something like that. Lindsay's then going to, in the second half, look at some case law update. There's been some really good case law, I think, coming through over the last 6 months. And I'm going to finish off with a legislation update, and we'll see what's on the horizon. We're definitely going to finish by 12. I think we'll probably finish a little before then. If we've got time for questions, please do fire those through and we'll try and answer them. If there's questions we can't answer, we'll try and do that in an FAQ section afterwards. There's the Q&A button or the chat button. Use either of those if you want. Probably the chat button's easiest, just to ask the questions as we go along. We'll try and get to those. We are recording this session, so hopefully you can sit back, relax and enjoy without vigorously scribbling down lots of notes, because you can enjoy this at your leisure, and we'll send out a link to you. So if you're not able to make the entire session, you'll still get the opportunity to hear what we've got to say right the way through. I think that's it in terms of kind of housekeeping. So I'll hand over to Lindsay to talk about the fallout from the pandemic.
Good morning, everyone. Thanks, Matt. So we're going to be talking this morning about some cases that have recently hit the tribunal to do with the fallout from the pandemic and lockdown. First of all, we're going to be kicking off with some furlough and redundancy cases, some refusals by employees to return to work, and some health and safety dismissals related to COVID-19. So we're going to be kicking off with the case of Minderwa and Loving Angels Care Limited. This is a case about an employee who was made redundant in the early months of COVID-19, and she argued that she should have been furloughed. So she was a live-in care assistant who provided live-in care for an elderly lady until February 2020, when this lady was moved into a care home. She asked to be furloughed in May 2020 and the employer refused. They said they couldn't offer her any more live-in care due to the restrictions that had been imposed to control the spread of the virus. And so she was dismissed for redundancy, and she claimed unfair dismissal. Now, her claim of unfair dismissal was upheld, and the reason for this was that in July 2020, a reasonable employer would have given due consideration as to whether or not she could have been furloughed, or she should have been furloughed, to avoid dismissing her on the grounds of redundancy. Now, the employer said they had no live-in work available. They could only offer her domiciliary care, which wasn't suitable because of the travelling involved. That was exactly the type of situation that the furlough scheme had envisaged. So it should have been considered what was suitable in that case. And the employer should have thought of that. Although they had no work for her at the time of dismissal, they had no way of knowing if that was going to change. And they didn't consider whether or not she should have been furloughed to wait and see if anything would become available. Now, this is actually a decision that came out of a tribunal. So it's not actually binding on other courts and tribunals, but it is a good warning to employers to consider that you should always consider the alternatives, particularly in these early stages of the furlough scheme. Obviously, we don't have that anymore, but the cost was neutral to the employer. There was a lot of uncertainty at the time, as we all remember, and there will be a difference between an employer who says, well, I considered the alternatives, in this case, the furlough scheme, but I discounted it because I knew we weren't going to be getting any more work, to one who says, well, I didn't furlough my employee I dismissed them because I didn't know what the future was going to look like with COVID. The former is more likely to be fair than the latter. So the point of the scheme at the time was to tide an employer over in the time of uncertainty. So I think for employers to take away from that is always consider the alternatives to dismissal. Okay, so we're going to be moving on to the case of Hundley and Tatton Aviation. So this was a man who was a flying instructor for a small business. They were a small private aviation company that gave private flying lessons, and he was told that he was going to be furloughed for 3 weeks or until he could return to work as normal. He was then made redundant in August 2020, and he argued that his furlough agreement prevented him from being dismissed. The company that he worked for had been struggling financially anyway, even prior to the pandemic, and they'd actually been considering redundancies as early as April 2020. Now, in this case, the tribunal accepted that his employer needed to cut costs, irrespective of the furlough scheme, and that it wanted to use the scheme to pay some of the costs of redundancy. And although another employer may have chosen to leave Mr. Hundley on furlough for longer, it wasn't unfair of the employer not to do so here. And the judge said, whilst another employer may have taken a different approach and chosen to leave the claimant on furlough for longer, it cannot be said that it was unfair of the respondent not to do so. It is for an employer, not the employment tribunal, to decide how to structure its business and whether to make redundancies. I accept the respondent's evidence that it needed to cut costs irrespective of the furlough scheme, and that it wanted to use the furlough scheme to pay some of the costs of making the redundancy. The nation was in unprecedented certainty at the time, and it is not for me to step into the shoes of the employer and substitute my view for that taken by the employer at the time. The decision to dismiss the claimant, notwithstanding the existence of the furlough scheme, does not, in my view, render the dismissal unfair. Now, Mr. Hundley's claim did succeed on procedural grounds because the employer hadn't followed a fair process, but there was a 100% chance that he would have been dismissed in any event, even if they had followed a fair procedure, so he received no compensation. Again, this is a tribunal case, so it's not binding on other courts, and it can be directly contrasted with the Minderwa case that I was just talking about. And the key will be whether or not the employer had considered furlough or an alternative, and having balanced everything up, whether or not they've concluded, even taking away any uncertainty, in this case the pandemic, they still need to cut costs. So that's something to always bear in mind if you're looking at a redundancy or a dismissal. So next we have the case of Montenero and Landsafe Limited. And this was a chap who was an IT professional. He worked in the UK and he took some annual leave to go to Italy for a wedding, and he got stuck there when the pandemic hit. Everything was shut down. Now, the guidance in Italy at the time was that you had to stay at home, but you could travel for work purposes. The UK government guidance at the time was that if you returned from Italy, you had to self-isolate for 14 days. So due to that unique situation, Mr. Montenero was unsure whether or not he would be allowed to travel without further documentation or evidence from his employer. So he called his employer in the UK, he explained all of that, and he was told to wait for further instructions. Unfortunately, no further instructions came, even though he contacted his manager. He carried on working remotely. Then he discovered he'd been dismissed on the 1st of April 2020 when he had an email which referred to his dismissal. So there was a dismissal letter which had been dated the March 2020. He said he never received that. The letter referred to unauthorised absence and said that he hadn't been in contact with his manager or provided reasons for his absence. Well, this was blatantly untrue. Also, they hadn't even invited him to a disciplinary hearing before the dismissal. And the tribunal said in this case, because of the outbreak of COVID-19, there was a circumstance of danger and a risk of serious illness or death. There'd been a declaration of a worldwide pandemic, so he reasonably believed that the virus was serious and imminent danger that could be avoided. And the tribunals had said that there had been no refusal to return to work by Mr. Montenero. Indeed, he was prepared to work remotely, but he was just stuck in Italy. The tribunal also found that the reasons for his dismissal that they put in the March letter were inaccurate and irrelevant to his circumstances. And also they didn't consider the letter to be credible evidence. So in other words, they were kind of doubting whether or not it had actually been sent. And they found that the employer had failed to provide adequate reasons, and therefore they committed a fundamental breach of his contract and he'd been unfairly dismissed. This is a fact-sensitive case, but it demonstrates that employers really need to be careful not to take rash decisions if, for an example, an employee is stranded or something like that happens, or if they express concerns for their health and safety. They need to take into account relevant government guidelines, as well as also having clear rules and procedures in place for annual leave and for working remotely. And always remember to make employees aware of this at the outset to avoid any misunderstandings. So next we have the case of Gibson and Lothian Leisure. This gentleman was a chef and he got furloughed at the beginning of the first national lockdown. Now, during the furlough and in the run up to the end of lockdown, so sort of June last year, his employer asked him to come into work. Now, he was worried about COVID because he lived with his father, who was clinically vulnerable. And so he raised concerns about the lack of PPE and the lack of a safe working environment. He was then dismissed, summarily by text, with no notice pay and no accrued holiday pay. Under section 44 and 100 of the Employment Rights Act, employees are protected from being subjected to a detriment or from being dismissed or from exercising their right to leave the workplace if they feel they're facing a threat of serious or imminent danger. And to gain such protection, the employees must have that reasonable belief that the workplace poses a serious or imminent threat to them or others. Now, this is a day one right. You don't need 2 years qualifying service to bring this kind of a claim. So Mr. Gibson took the employer to tribunal and his claim succeeded. He won for automatic unfair dismissal. The circumstance of the danger was the growing prevalence of infections of COVID and the potential harm that could be done to his father. And he reasonably believed that, which is why he raised the issue of PPE. And that amounted to an appropriate step to protect his father from the danger. And he was awarded over £21,000 in compensation. So don't forget, there's no qualifying period for employment to benefit from these protections for employees, and compensation for a successful claim of this kind is uncapped. And existing case law suggests that these concepts can be broadly interpreted, so the danger doesn't have to be in the workplace itself, and whether or not an employee's belief is reasonable will depend on factors such as the extent to which the employer has assessed risks and followed the guidance, whether any safeguards such as PPE can be provided or other mitigation measures can be taken, whether the work means that certain safeguards can't be taken, and also the vulnerability of the employee. So this is something to bear in mind for employers, whether or not the employee's belief that the serious and imminent danger is reasonable. So always follow government guidance, we would say in this case, and obviously take advice as to the specific circumstances. And we're going to contrast this case with another case later I'm going to be talking about, called Rogers and Leeds laser cutting, and we will get to that shortly. Okay, so our next case is Tatton and Wynn Solicitors Limited. And in this case, an employment tribunal found that a solicitor had been unfairly dismissed for refusing to agree to changes to her employment contract that would have given the employer the freedom to unilaterally reduce her pay and hours to 80% or to place her on furlough. And the dismissal was unfair due to a lack of meaningful consultation and a failure to reasonably consider alternatives to dismissal. Now, we go back to the beginning. At the start of the pandemic, the respondent, the firm of solicitors in this case, decided to place half of their staff on furlough, and the other half they retained, subject to them adopting the work of their furloughed colleagues and agreeing to this contractual variation. The claimant was told this in person, that she could continue to work, and then she was notified of this proposed variation. The variations allowed the respondent to do a few things. First of all, they could place her on furlough, or they could reduce her hours and her pay by up to 20% on 5 days' notice until October 2020. These variations also allowed the respondent to extend the terms by a further 3 months if the business so required it. Now, these new terms were sent to the claimant by email on the 24th of March 2020 with instructions that she sign the document and return it within 24 hours. So not giving her much time there. Again, it was explained to her that if she didn't sign, they would dismiss her. She refused. She said she wasn't going to agree because she was still performing the role she was contracted to do. However, she did say she'd be willing to consider them if she was to be furloughed. Again, there was a bit of back and forth. The respondent told her that she had to agree. She remained steadfast in her refusal, and on the 26th of March, the Chief Operating Officer, the COO of the firm, instructed that her employment was to be terminated without notice. And she didn't receive any payment in lieu of notice or her accrued holiday pay. And this action was justified by the CEO, who said that her action showed that she was clearly not someone interested in the firm or her colleagues. Her IT access was terminated that afternoon, and it was only after she queried this, she was told she'd been dismissed. Later, the respondent did actually pay her notice pay and holiday pay because they then accepted they'd breached her contract. Nonetheless, she still brought a claim to the Employment Tribunal for an unfair dismissal. And the tribunal decided that the dismissal was unfair due to the employer's failure to undertake a proper dismissal process. They didn't enter into any consultation with her over the contractual change. They didn't give her an opportunity to talk through her reasons for refusal. And in addition, they hadn't offered her an appeal to the dismissal. Now, the assessment of whether a dismissal is fair or not, as many of you already know, looks at both the reason for the dismissal and how it was carried out. Now, in actual fact, failure to agree to variations to her contractual terms and conditions could have been a fair reason for her dismissal, because it can fall within the some other substantial reason definition. However, whether it was or wasn't was not actually tested in this case due to the fact that the dismissal was unfair on the grounds of lack of procedure. Now, this case doesn't indicate that that particular reason for dismissal would always be fair. Every case will be assessed on its own facts, taking into consideration the reason for the dismissal and the procedure used. Either way, this is an important reminder for employers that a correct procedure must always be followed. And this case failed because, as I said, the employer had failed to go through a proper procedure, and the tribunal highlighted that the immediacy of a given situation, in this case, the pressure from the pandemic, was no excuse for not going through that proper process. Okay, so now we're going to look at the case of Rogers and Leeds laser cutting. So this is going to contrast with the previous case of Gibson and Lothian that I was talking about. And it's a health and safety issue. Again, looking at the protections that employees receive under Section 44 and 100 of the Employment Rights Act 1996, which protects employees from being dismissed for exercising their right to leave if they have reasonable belief that the workplace has a serious or imminent threat to them or others. Now, in this case, there was a risk assessment that the employer had done. They put in place various safety measures, including staggered start and finish times, masks, social distancing, increased hygiene, the sort of things that most of us were seeing and doing around that time. 2 days later, Mr. Rogers said he won't be coming into work until lockdown has eased because he was concerned about contracting COVID and infecting his vulnerable children. He was dismissed. He claimed it was automatically unfair because he reasonably believed he was in serious and imminent danger, and he took steps to protect himself and other people from that danger. Now, in contrast to the other case, his claim was dismissed. The tribunal accepted that Mr. Rogers did have significant concerns about COVID, but that was not enough to bring him within the scope of the statutory protection because the communication he'd had with his manager hadn't mentioned any workplace dangers. So he couldn't show that there was in fact danger. And also his employer had implemented all the recommended government guidelines that it was possible to implement. Secondly, despite his alleged concerns about COVID, he had actually breached self-isolation guidelines himself to drive his friend to hospital. And he hadn't taken steps to avert the alleged danger or raised concerns with his manager before he'd left work. He'd just gone. Again, this decision isn't binding on other courts and tribunals because it's a tribunal decision. It's fact sensitive, but it is a reminder to employers that whilst there were no circumstances of serious or imminent danger in this case, any failure to put in place adequate COVID-19 measures would expose you to risks of these claims in the future. The mere existence of the virus wasn't enough to get Mr. Rogers over that hurdle. But his evidence was also found to be vague and contradictory anyway, because he hadn't raised any concerns of this kind before he'd left work. And that's another reason why he didn't succeed. But again, a reminder to employers to always implement health and safety measures and follow government guidance in this case. Okay, right. So I'm going to hand back over now to Matt.
Thanks, Lindsay, for that very interesting guide to some of the latest cases with the fallout from the pandemic and lockdown. Some really interesting things on that. I thought the Leeds laser cutting case was particularly interesting in terms of how the tribunal approached these matters. And as I explained right at the beginning, I've had a few technical issues, so Lindsay's going to work the slides for me. And my session before we break is on flexible working and how far do employers need to bend. And this is really as a result of the consultation that the government launched kind of mid-September with regard to how they propose to make changes to flexible working. Now, the response from the government doesn't actually say what changes they make. They do it in the form of questions as to what they intend or what might change. But I think it gives you a good idea of the direction of travel as to the changes that we're likely to see. So before we get into that, just a reminder on what is flexible working. Well, it's really three things: change to hours of work, so someone wanting to go from full-time to part-time, that's flexible working. Change to the times when you're required to work, so if you wanted to go to a compressed hours or term time working or flexi time, that would still be flexible working. The third element really, which is important, I think, in the current climate, is to the change of place of work. And that could be you want to work fully from home, or it could be that you want to work partly in the office or partly at home, which of course we're starting to see more and more issues now as people start to be asked to return to the office, having done largely home-based working roles for 18 months or so. So that kind of sets the context of what we're looking at with flexible working. Next slide, please, Lindsay. And that impact of the pandemic and lockdown on flexible working, anecdotally, we've all felt it. But, the height of the first lockdown, 47% of the workforce were working from home. That's a huge amount. And I think that led particularly employees for that increased recognition of the need to balance work with other personal commitments. I'm sure, like many who are listening today, you've enjoyed not having to do that 5-day-a-week commute. You've enjoyed the time that's given you back to your family life and other personal commitments. And I think employees want to keep an element of that. There's certainly, I think, a change in some employers' thinking as well. Some statistics there from a survey I saw recently, about 74% intend to increase home working arrangements, and 43% of employers intend to increase flexible working more generally. And as we'll see at the end of this, I think part of that is driven by the current recruitment market. And what we are seeing, and what I'm seeing from my clients, and I know is out there in the wider employment marketplace, is an increase in flexible working requests as employers require return to the office, because employees are starting to say to their employers, well, actually, I don't want to go back to the office 5 days a week. I want to continue working from home entirely, or what we're seeing a lot more of is I want a mix. I want a hybrid of working in the office and working from home. And if I can't agree to that, then I'm going to put in a flexible working request to force the employer at least to consider that in more detail. Next slide, please, Lindsay. So I thought it'd be interesting. I appreciate there's lots of experienced practitioners out there, so I'm not going to spend ages on this, on the current right to request flexible working and teach you how to suck eggs, as it were. But first of all, of course, it's a right to request, not default right to work flexibly. I know sometimes employees don't always appreciate the difference, but it is a right to request. It's currently open to all employees with 26 weeks plus service, so there is that service qualification. Employees have to trigger the process by making a written request, and that written request should contain quite a good deal of detail. Employers have 3 months to deal with and notify the employee of the decision from the request being made. And of course, as many of you know, when dealing with requests within the regulations themselves, there's 8 business reasons for rejecting a request. And those include things like extra costs that will be a burden on the business, or the work cannot be reorganized amongst other staff. And I think most employers who've got an objective reason for turning down a flexible working request will be able to ensure that they can rely on one or more of those 8 reasons. And in terms of the process itself, it's certainly a light touch. Some of you may remember when the flexible working regulations were first introduced, there was quite a tortuous process that employers and employees had to follow in terms of timescales and things like that. That was amended, and we've now got a light touch process which requires employers to consider requests in a reasonable manner. I think employers still follow some kind of process in order to give that a framework, but it's certainly not the kind of very drawn out process that we had right at the start of the regulations. But what we have seen is the government, I think, recognizing perhaps that current system doesn't work. I still think I saw some statistics the other day where the majority of flexible working requests aren't granted. And I think there's an idea that perhaps we need to revisit the regulations in order to give them a bit more impact. Next slide, please, Lindsay. And in particular, I think it's been revisited with the lens of the pandemic. And the consultation is quite clear on this. And it says, as I put the quote here, it's opened our eyes to what may be possible. And now we have the chance to seize the moment and make flexible working in all its forms part of the business DNA. So there's a clear view that we need to move forward with flexible working and encourage flexible working. And the regulations, the government thinks, need to be changed in order to do that. So what are those changes likely to look like? So next slide, please, Lindsay. Well, as I say, this will give you a hint, I think, on what we may see ultimately as the changes. The government is seeking views on whether or not we should make the right to request flexible working a day one right, so removing that 26-week service qualification. I think that will be helpful, but I think the reality is that employees are going to want those flexible working arrangements in place from the start of their employment. And I'm not sure an employee will get any particular benefit from being able to make that request on day one, as opposed to after 26 months. I think actually employees and prospective employees will start wanting to make those requests earlier, rather than just waiting till they've started employment. We're also going to have a look at whether those 8 statutory business reasons for refusing a request remain valid. And we may see, I think, some tinkering around the fringes of those, but ultimately, I don't think we're going to see some fundamental reforms to that. We are, however, perhaps going to see a requirement for an employer to suggest alternatives, where a request to work flexibly cannot be accommodated. At the moment, often flexible working requests are quite binary. It's either granted or it isn't. And I think a new right where employers will have to look at perhaps other alternatives if they cannot grant the particular request that's being asked for, I think will be interesting. Also looking at perhaps amending the current process to make a request. It's difficult to amend it too far because it is a fairly light touch at the moment, but I think we may see a reduction in the response times down from that 3 months. I could see that being shortened. And those of you who are familiar with the regulations as they currently stand will know that actually a flexible working request is a permanent change to an employee's working arrangements. But often flexible working requests could be made because of some temporary need to work flexibly. Could be a particular care need or family issue that's arisen. And so if we could have flexible working that was a temporary arrangement, that again, I think may extend the use of and see more applications granted for flexible working. Next slide, please. But of course, what many of you will have noticed already as I'm talking is that it's still only going to be a right to request flexible working. And I think some of the publicity that went with the announcement on the consultation on flexible working was somewhat misleading. Because you'd be forgiven for reading some of the press releases that what we were talking about was a default right to work flexibly. That's not the case. Interestingly, though, the government did consider this whether it should be a default right to have flexible working, but I think recognise many of the issues that I'm sure the attendees will have thought about for such a right, in that for a lot of cases, that's just not going to be practical. And they said here, given the range of different roles and way of working within them, that sort of default right to work flexibly just simply is not going to be achievable in a practical or sensible way. Next slide, please, Lindsay. So will anything change? Well, again, if an employer follows the regulations and turns down a request for flexible working, then within the regulations, there's very little that an employee can do to challenge that decision to reject the request. And whilst we may see some tinkering around the fringes with the regulations, I still think fundamentally that's going to be the position with the regulations. So will the sort of changes that we're talking about make any differences at all? Well, I think there will be changes to how employers have to deal with flexible working requests. And I think that's going to be borne out by 2 issues. And next slide, please, Lindsay. Because what happens, particularly when we see flexible working requests from females in the workplace, is that if those are turned down, then you are going to see the potential for indirect sex discrimination claims. And I think the potential for those claims has increased. And I think we'll see that for a number of reasons. So next slide, please, Lindsay. First of all is the childcare disparity. Now, just to explain the childcare disparity, which is at the heart of a lot of these indirect sex discrimination claims, in summary, it's because women, because of their childcare responsibilities, are less likely to be able to accommodate certain working patterns than men. So, for example, it's harder for women to accommodate full-time work. And in the context, I think, of a return to work after the lockdown arrangements, it's harder for women because of childcare responsibilities to accommodate a requirement to work full-time in the office rather than at home. And that childcare disparity, as I say, lies at the heart of many of these indirect sex discrimination cases. Now, one of the things that you find with these cases, though, is that employment tribunals can require an employee, as part of the claim, to produce statistics to back up that childcare disparity. And that's what's happened in the case of Dobson and North Cumbria Integrated Care NHS Foundation Trust. And one of the reasons why Mrs. Dobson's claim was rejected was because the tribunal said she hadn't advanced any evidence, any statistical evidence to back up the childcare disparity that she was relying on. Now, I'm sure that may come as a surprise to you, because I think many people listening to this webinar will recognise that that childcare disparity exists. And the Employment Appeal Tribunal, I think, were unimpressed with the Employment Tribunal's approach on this. And what they said is that tribunals hearing indirect sex discrimination claims should take judicial notice of childcare disparity. Next slide, please, Lindsay. So what that means in terms of judicial notice, these are facts that are so notorious or so well established to the knowledge of the court, they can be accepted without further inquiry. So in essence, the childcare disparity should be taken as read in indirect sex discrimination claims when you're looking at flexible working outcomes. It shouldn't then be for the employee to have to prove that by advancing statistical evidence. The impact of that, I think, it will certainly make it easier for employees to bring indirect sex discrimination claims, because that procedural hurdle of having to gather and advance that statistical evidence just won't be there anymore. Of course, ultimately, you'll still have an employment tribunal looking at the objective justification for turning down a request as part of that indirect sex discrimination claim. But I do think we'll see more claims being brought around rejection of flexible working requests because of this childcare disparity case. Next slide, please, Lindsay. And also, as well as the childcare disparity, what we are seeing now, and I think what we'll continue to see, is employment tribunals being far more impactful in how they look at challenging employers' decisions over flexible working requests in the context of indirect sex discrimination claims. And the Thompson v Scancrown Limited case is a very cautionary tale for employers and did get some publicity a couple of months ago. In this case, the employee requested a change to hours on her return from maternity leave. She actually only wanted to go down from 6 p.m. finish to a 5 p.m. finish, and that was due to her childcare responsibilities. That request was rejected by the employer, and they really didn't go into a lot of detail as to why they were rejecting the request. They simply, I think, referred to a number of the statutory reasons set out in the regulations, but gave no real substance behind them. The employee in question brought a number of claims, including indirect sex discrimination claim, where she was relying on this childcare disparity as part of the claim. Next slide, please, Lindsay. Well, this employee, apart from the indirect sex discrimination claim, lost all of those claims before a tribunal, but she was successful in her indirect sex discrimination claim, and she was awarded £180,000 compensation. Now, certainly a significant chunk of that compensation was loss of earnings, but there was also a significant amount for an injury to feelings award. And really, the crux of the tribunal decision was that the employer in this case really hadn't done anything to show that their refusal met any sort of objective or legitimate business need. And the tribunal said quite clearly, our conclusion is the respondent has not shown the refusal of the proposed reduction in hours was proportionate to the real needs of the business. And so what I think employers who are dealing with flexible working requests, I know it's things I've talked with clients very recently about, I think you're going to have to do far more in terms of providing detail as to why you're rejecting a request than you've done previously. You know, relying on anecdotal sort of comments that, oh no, there'll be an impact on quality or performance isn't going to be enough. You're going to have to, I think, produce properly thought out reasoned decisions with the evidence to back that up. Because if not, you're going to run the risk of these indirect discrimination claims. Next slide, please, Lindsay. And it's not just indirect sex discrimination claims, because we've also seen in the last few months the very interesting case of Fellows v Nationwide Building Society. Now, this was a case of indirect associative disability discrimination, and it arose because Nationwide required Mrs. Fellows to move from complete home working to complete office working. Now, the primary reason why Mrs. Fellows wanted to work from home was to care for her disabled mother. Now, Nationwide pushed through with this, and Mrs. Fellows brought a claim including an indirect associative disability discrimination claim, and she was successful. Now, in kind of echoes of the Scan Crown case, which I've just talked about for sex discrimination, Nationwide were criticised and heavily criticised by the Employment Tribunal because they'd not provided any evidence on which their decision where they were requiring this move from home working to office working, they'd not provided evidence of that. And they'd ignored Mrs. Fellow's views that the role could continue as per existing arrangements. So what we're seeing here, I think, is the tribunals rolling up their sleeves and being far more interested in decision-making around flexible working requests. And you're going to need, as an employer, to make sure, as I say, that you're giving proper thought to those requests. And if you're turning down requests, making sure that you're putting full detail in any rejection response, so that it's very clear as to the reasons why you weren't able to grant a particular flexible working request. Next slide, please, Lindsay. So not only do I think, though, that employment tribunals will kind of almost take employers beyond whatever the flexible working regulation changes might mean, I think the current employment market will take employers beyond that. Because, of course, the last 18 months have opened employees' eyes to a very different way of working. I'm sure we've all embraced, those of us who've been able to work from home, have embraced working from home to quite a large degree. You know, I, for one, certainly don't miss that 5-day-a-week commute, particularly given the traffic getting over to the office today to do this webinar. It reminded me of sort of the bad old days. And I think employers have realised, certainly employees have realised, that they can get time back that they didn't have before. And that's, I think, reflected in a survey that I saw that said 43% of employees are likely to resign if they don't get flexible working they want. And certainly I'm hearing from clients of mine and people in the recruitment business that employees and candidates are being far more upfront and proactive around the flexible working that they want. And, you know, talking to one recruiter recently who recruits into some fairly senior roles in the city, they were saying that candidates at a very early level are asking the questions around, well, is hybrid or flexible working available? And if the answer is no, this is a 5-day-a-week role in the office, they're simply rejecting that out of hand. It's not something that they're interested in. So almost regardless of what the flexible working regulations say, I think employers who want to keep good staff, want to retain and recruit good quality staff, are going to have to look to embrace flexible working, because employees will vote with their feet if you don't. We've also then got question marks, haven't we, over the death of the office and the hybrid working model. I think the death of the office is somewhat overblown. You know, if anyone's interested, we did a podcast a while back with one of the partners in my commercial property team, Julia Ferguson, looking at that very topic. I think we both thought that whilst office space may reconfigure and be used in a slightly different way, employers by and large will want to keep the office and will want to have some office working. So I think for many employers, you're looking at hybrid working. But if you're going to start telling employees that they should be returning to the office for collaboration and because of the culture of the business, I think offices themselves are going to have to change to suit that collaboration sort of culture building. You know, hidden away in individual offices isn't going to do that. So I think there's some fascinating practical aspects that employers are going to need to face, regardless of whether or not the flexible working regulation amendments that are proposed are actually going to make any significant changes to flexible working going forward. So hopefully that was an interesting overview of flexible working and the proposed changes and some of the challenges, particularly out of recent cases, that employers are facing. But what we're going to do now is we're going to, as I say, the second half, Lindsay's going to look at some kind of general case law update, of which there's been some really interesting cases coming through. And then I'm going to take a look at kind of the employment law horizon, what sort of other employment law kind of legislation changes are coming through. So I'm going to hand over to Lindsay, who's going to take us through the case law session. Lindsay.
Thanks, Matt. So here we go. As Matt said, there's been some really interesting cases coming through recently. We're going to be looking at some cases covering gender critical beliefs and philosophical belief discrimination, some cases on headscarf bans and religious discrimination, the burden of proof in discrimination cases, Interim relief and discrimination cases, some recent equal pay claims that you've probably been reading about in the press, a case dealing with sleep-in shifts and national minimum wage, and finally a case dealing with some other substantial reason dismissal for a teacher who possessed indecent images of children. So we're going to start off with by talking about the burden of proof in discrimination cases. Now, this is a case of Royal Mail Group and Phobia. This was a Supreme Court case, and they delivered a unanimous decision about the burden of proof in discrimination cases that confirmed that the claimant still bears the initial burden of proof, which historically is how it's always been, to establish a prima facie case of discrimination. So the background to this is that Mr. Phobia was a postman for Royal Mail, and during his employment with them, he actually applied for over 30 IT-related roles with Royal Mail. He was unsuccessful in all of them, so he brought claims of direct discrimination because of that. Now, when the case got to a full hearing in front of the judge, the Royal Mail didn't call the actual decision makers who were responsible for rejecting his job applications. Instead, what they did was they called two managers who were familiar with the recruitment process and how appointments were made in general terms. So, firstly, his direct discrimination claim was dismissed, and there were two grounds of appeal before the Supreme Court. So, first of all, Mr. Phobia argued that the tribunal had incorrectly interpreted the Equality Act, which deals with the burden of proof in discrimination cases. So what he was saying was that the previous legislation under Sex Discrimination Act and Race Discrimination Act, before that all became amalgamated into the Equality Act, had a slightly different burden of proof. And when the Equality Act amalgamated those pieces of legislation, that it wasn't such an onerous burden on the employee. And he also appealed on the ground that the tribunal ought to have drawn adverse inferences from the fact that the Royal Mail didn't call the decision makers as witnesses. Now, the court said that mere assertions that discrimination has occurred from the claimant will not shift the burden of proof to the employer. What the claimant has to do in a discrimination case, because the burden of proof is on them, is that they really have to prove those facts to support their allegations before the burden will then shift to the employer, who has to then show that any acts or omissions or failures were on the grounds of something else, i.e. not discrimination. The court said in the present case, there was nothing to suggest that the tribunal had thought that it was precluded from drawing adverse inferences about the witnesses called by Royal Mail. It had simply declined to do so, and that decision was not perverse on the facts of the case, and that's why the appeal failed. This is a good result because it confirms that the law is unchanged in the Equality Act. And it also, the court made the point that it would be unduly onerous to require an employer to disprove a mere assertion of discrimination before the burden of proof jumped to them. But I think in this case, it's really worth bearing in mind, the employer still has to present evidence to dispute and defend a claim. And if you ever have to reject a job application or dismiss somebody with a protected characteristic, that you should always make sure that you've got good evidence to defend yourself, just in case you have a claim of this kind. We're now moving on to a religious discrimination case. This is the case of IX and WABE. This was a case in Germany that went through the German courts all the way up to the European Court of Justice, the ECJ. And the ECJ held that a ban of workers wearing visible signs of political, philosophical, or religious beliefs in the workplace does not necessarily constitute direct or indirect religious or belief discrimination under the Equality Act. So in this case, in the IX case, this lady wore a headscarf. Her employer asked her to remove it in line with their policy. It was a nursery school, and she was asked not to show any visible signs to parents, children, or third parties of her philosophical or religious belief. And she was disciplined when she refused to remove her headscarf. She was asked to attend work without any conspicuous sign of political or religious belief. Now, the European Court said that because this was a universal rule, so it applied to all kinds of religion, so it was going to affect her wearing the headscarf, or it could even affect a Christian person who might just wear a small cross or crucifix, for example, that it couldn't constitute direct discrimination because it didn't target the adherents of any specific religions. It was a universal application, and it drew no distinctions between any different types of visible signs. And that is the case even though it caused inconvenience for workers who observe religious precepts that require certain clothing to be worn. So they also asked the question, could it be indirectly discriminatory? They said no. Justification can be established when an employer can show that they have a genuine need for the policy, and to establish such a need, account must be taken of the rights and legitimate wishes of customers or service users, such as parents, with the right to ensure that the education and teaching of their children in accordance with religious, philosophical and teaching beliefs that they wish their children to have, that they wish their children to be supervised by persons who don't manifest their religion. This contrast at the time, another similar case also in Germany about a lady who wore the hijab, headscarf. This was a case called MH Müller Handels, and the policy for that employer prohibited the wearing of conspicuous large-sized signs of political, philosophical and religious belief. And the ECJ in that case said that that was likely to be direct discrimination, because unlike a universal ban of such signs, a rule which only prohibited conspicuous large signs is liable to be seen as targeting a particular religion like Islam, because if you're wearing the hijab, obviously that's more conspicuous than a small cross or crucifix, for example. So just to comment on that, these judgments come from the ECJ post-Brexit, so they're not actually binding on our courts, but it's a useful reminder and help to our courts that they can have regard to them if they're considering any relevant cases of this kind. And now we're going to be moving on to a case of Forstater in CGD Europe. This is a case regarding philosophical belief discrimination. This lady, Ms. Forstater, was a visiting fellow at CGD Europe, and she believed, and this is similar to the row that broke out last year when I think J.K. Rowling put similar views on Twitter. She believed that it was impossible for a person to change their sex, irrespective of any change that they might make physically and through surgery, accident, illness, or force of will. Now, she expressed these views on social media in debates. Some of her work colleagues considered these to be offensive, and following an investigation, her fellowship was not renewed. So she claimed discrimination because of her gender-critical beliefs, and she said that they were philosophical beliefs capable of protection under the Equality Act. The Employment Tribunal said no. She appealed to the Appeal Tribunal, and they said yes. But when is a belief capable of protection? Well, we've seen recently another case where veganism is actually capable of being a protected philosophical belief under the Equality Act. So why not this? The Appeal Tribunal looked at a 5-stage test. Now, this is a case of Granger PLC and Nicholson that they used. Now, first of all, the tribunal set this out when they heard Ms. Forstater's case. And you need 5 criteria to establish that a political belief can be capable of respect. So first of all, it's a genuine political belief. It has to be genuinely held. Number 2, it has to be a belief and not just an opinion or a viewpoint based on the present state of information available. 3, it must be a belief as to a weighty and substantial aspect of human life and behaviour. 4, it must attain a certain level of cogency, seriousness, cohesion, and importance. And the 5th stage, which was the one we're going to be talking about now, is that it must be worthy of respect in a democratic society and not be incompatible with human dignity and not conflict with the fundamental rights of others. So that's where the tribunal said that her belief wasn't worthy of respect in democratic society, but the EAT said that it was. And the reason that the appeal tribunal said that she satisfied the 5th Granger criterion is because they said that there is scope for certain beliefs to be excluded from protection from the Equality Act because of the European Convention on Human Rights, but that would only arise where that belief is akin to Nazism or totalitarianism. And they said that whilst Ms. Forstadter's belief may have been considered offensive, shocking, or disturbing to some, it was not, in the view of the EAT, a belief that sought to destroy the rights of others, like Nazism or totalitarianism would. So her belief didn't seek to destroy the rights of trans people. It was therefore worthy of respect in a democratic society. And ultimately, they concluded that a person is free in a democratic society to hold any belief they wish, subject only to some modest, objective, and minimum requirements. So what does this mean? Well, this means that the threshold for demonstrating a philosophical belief has been lowered, but this has been sent back to a new tribunal who would have to consider whether or not CGD Europe's actions amounted to discrimination against Ms. Forstadter. What doesn't it mean? Doesn't mean she's been discriminated against. As I say, it's got to go back to another tribunal to decide that. It doesn't mean that those with gender critical beliefs can misgender trans persons with immunity. Ms. Forstadter, like everyone else, is subject to the prohibitions on discrimination, harassment, and the Equality Act. So it doesn't mean that you can go around calling a trans woman he, for example. It doesn't mean that trans people don't have protection against harassment and discrimination. If any of you have come across the recent case of Taylor and Jaguar Land Rover, which was a recent decision about a trans woman treated appallingly, the tribunal found, by Jaguar Land Rover, have a look at that and have a read of that. It's very interesting. She identified as non-binary and was capable of protection. So it's really important to remember that it is incumbent on employers to ensure that their employees tolerate an opposing belief and act in a non-offensive way towards others. Employers must provide a safe environment for trans people. And I think this really highlights the importance, again, of regular, effective equality and diversity training for staff. Obviously, take advice on that and make sure that your equal opportunities policies and training manuals are all up to date as well. Okay, so now we're going to be moving on to a case regarding interim relief in discrimination cases. This is the case of Steer and Storm Shaw Limited. The power to grant interim relief is currently not allowed in discrimination cases. What is interim relief, you might be asking yourself? Interim relief restores the employee's pay whilst waiting for a tribunal decision on a claim. The circumstances in which you get interim relief are quite specific and quite narrow. So you can only make that application if the principal reason for your dismissal is alleged to be carrying out health and safety activities or performance of any duties as a workforce rep or a trade union rep, performance of functions as a trustee of a pension scheme, or to do with TUPE, being a collective consultation employee rep, for example, under TUPE, for whistleblowing or trade union activities. You don't normally get it for sex discrimination. Now, in this case, Ms. Steer was 4 months into her role at Storm Shaw, and she alleged sexual harassment in the workplace. So she asked the employer to investigate, and she asked to work from home because of this. The employer reluctantly agreed, but they then cut her hours due to her childcare commitments, and she then resigned and claimed constructive dismissal and sex discrimination. She claimed that she was entitled to interim relief under the Employment Rights Act and the Equality Act. The tribunal said it had no jurisdiction to hear the claim. So it sent the interim relief claim to the Employment Appeal Tribunal. They said it raised complex issues of EU law. And Ms. Steer argued that because there was a disparity in protection, this breached EU law and Article 14 of the European Convention on Human Rights. She was partially successful at the EAT, but they rejected her arguments on EU law. And they said that in the absence of interim relief didn't breach Article 14 of the European Convention on Human Rights, but they couldn't go any further than that. It went to the Court of Appeal, who they said would have to make a declaration of incompatibility between European legislation and domestic law. But the Court of Appeal dismissed it and said that the European Convention on Human Rights couldn't help her argument about interim relief and the incompatibility with domestic legislation, and it wasn't up to them to deal with that, but that was a matter for Parliament and the government to legislate to make any changes if there was incompatibility between EU law and domestic law, and it wasn't for the courts to do that. So this is a sigh of relief for employers, although the hurdle for an employee being able to claim interim relief is relatively high because they have to persuade the court also that they're likely to succeed in their ultimate dismissal, unfair dismissal claim or discrimination claim. To allow interim relief to discrimination would add another layer of litigation and cost, which would mean that the backlog of tribunal cases that we've already got would build up even further. So the tribunal service are also probably breathing a sigh of relief about that as well. Now, you may have read about this in the press, these equal pay claims that we've got for Asda and Tesco. That's also been on the news quite a lot, actually. Thousands, actually, current and former Asda and Tesco workers have won a legal argument. The Supreme Court ruled that they can compare their roles. The shop workers can compare their roles with those of their colleagues in distribution centres for the purposes of equal pay. Supermarkets have always defended themselves by saying that the work is different, but whilst we've got this judgment from the courts, it doesn't mean that everybody's now going to get a pay rise who works in the shop. But either way, this ruling's not good news for supermarkets, although these workers shouldn't think that they're getting a pay rise. The supermarkets are still arguing that there's a substantial difference in the roles, and that justifies the difference in pay. Claims have now expanded. We've got claims now against Sainsbury's, Morrison's and the Co-op. These claims are extremely complex and they're going to take a long time to reach conclusion, so watch this space. Okay, so this is the case of Royal Mencat Society in Tomlinson. This is about a care worker who worked day shifts and sleep-in shifts and was allowed a shift allowance for the sleep-ins and 1 hour's pay. She was permitted to sleep during this period, but she was required to remain at the home of the 2 vulnerable adults whom she cared for throughout the sleep-in shifts. But she didn't have any actual duties to perform in the night except to keep a listening ear and just to be there. So obviously if there was an emergency or if they needed her, she was required to attend to them. It was found that she'd actually only been disturbed 6 times in the period of 16 months preceding the hearing. And she brought proceedings arguing that she was entitled to be paid national minimum wage for each hour of her sleep-in shift, and the tribunal agreed. Mencat appealed to the appeal tribunal on the basis that she was sleeping, and national minimum wage regulations say that time work includes hours when a worker is available and required to be available at or near a place of work for the purposes of working unless the worker is at home. In paragraph 1, hours when a worker is available only includes hours when the worker is awake for the purposes of working, even if a worker by arrangement sleeps at or near a place of work and the employer provides suitable facilities for sleeping. The Supreme Court concluded that a worker who is merely present is treated as not working for the purposes of calculating hours which are to be taken into account for national minimum wage purposes, and the fact that Ms. Tomlinson was required to be present during specified hours was insufficient to conclude that she was actually working. Now, this decision will be a relief to the care sector, which has seen this decision going backwards and forwards for, I think, several years now, actually. They would have had to face claims which would put them in financial jeopardy. And the Supreme Court was unanimous in this decision. So these employers can carry on the practice of paying a flat rate for sleep-ins, safe in the knowledge that they're not falling foul of national minimum wage regulations, but they should always take steps to ensure that any time that the sleeping worker spends awake for the purposes of working is remunerated at least national minimum wage. So that, yes, when a worker's required to be at the workplace outside normal working hours with the expectation that he or she will be required to work, because then that would attract national minimum wage. So there's a difference between sleeping shifts and on-call arrangements. Okay, so this is a case regarding some other substantial reason dismissal, the case of L and K. This might provide some welcome clarification for schools dealing with teachers accused of serious misconduct involving children. In this case, the claimant teacher had been charged with possessing indecent images of children. They were found on his home computer. He admitted that such images had been found on his home computer, but the relevant machine was shared with his son, who he also lived with, and he denied all knowledge of how those images came to be on his computer. The CPS ultimately made the decision not to prosecute. They dropped the charges, but they reserved their right to do so. He was then dismissed following an internal disciplinary process. He was initially unsuccessful in his claim for unfair dismissal in the Employment Tribunal, and they found that although he'd been charged with misconduct in the disciplinary proceedings, he was dismissed. He was actually dismissed not for misconduct, but for some other substantial reason. And that was due to concerns that he may have been guilty of this offence, and therefore that was an unacceptable risk to the children and a reputational risk to the school. And the tribunal was satisfied that the test for some other substantial reason dismissal had been met. Now, the Employment Appeal Tribunal disagreed with this, and they ruled that because the claimant had originally been charged with misconduct, the school couldn't then establish a reasonable belief that he was guilty of the misconduct in question, and they weren't entitled to dismiss on other grounds, and therefore the dismissal was unfair. The school appealed on the basis that the EAT couldn't overturn the tribunal's decision because there hadn't been an error of law. The EAT had taken a different view of the facts, and that was not its place. And moreover, the dismissal hadn't been for misconduct, it had been for some other substantial reason, and the EAT had failed to properly consider the particular duties of the school to ensure the safety of its pupils. This then went to the Court of Session. They agreed with the school and they restored the tribunal's finding. The court held that having established that the reason for the dismissal was some other substantial reason, the question for the tribunal was whether the school had acted reasonably in proceeding with the dismissal on that basis. And the tribunal was entitled to find on the facts that the school had acted reasonably. Now, this case, as I said, provides some welcome reassurance to schools faced with difficult safeguarding investigations which might not meet the threshold for misconduct. Any disciplinary procedures in safeguarding cases must be approached really carefully and with sensitivity, and we would always recommend taking specialist advice on that before proceeding with the dismissal. The facts of each case are going to be important in determining what is a fair course of action in that particular case to take. More broadly, all employers should be alert to ensuring that charges set out in disciplinary process reflect the employee's full case, the employer's full case. So including things such as reputational damage, that might be peripheral to a misconduct charge, but it might be sufficient to justify dismissal in their own right. So be clear about the range of charges in any dismissal process that you undertake or disciplinary process, and any possible outcomes from the outset, because that will support both the substantive and the procedural fairness of a dismissal. Okay, so I'm going to hand over now back to Matt for a legislation update.
Thanks, Lindsay, for that case law update. Lots of interesting cases out there. I thought the Forstater and philosophical belief discrimination case was particularly important, and thanks for taking us through that and highlighting what some of those case law actually mean for employers in a practical sense. So, as Lindsay said, I'm going to finish up the session now looking at a legislation update. Now, you may be forgiven for thinking that you know, we haven't seen any really major changes to employment law legislation absent sort of furlough. And of course, I've talked earlier about the changes to flexible working, but actually there's been certainly some changes and proposed changes that I think are worth highlighting. Next slide, please, Lindsay. Now, of course, mandatory vaccinations in the UK, this has got a lot of publicity over the last couple of days. And first of all, let me just touch on care homes, because vaccination is, or will be from tomorrow, the 11th of November, a condition of deployment in care homes. And that's going to apply to all persons who enter a care home, which obviously will include their employees. So, you know, we are starting to see, certainly first time, you know, within a kind of wider employment context, kind of that compulsory vaccination requirement in the UK for employees to continue in their role, which actually is, you know, we've never really had that before. Next slide, please, Lindsay. Now, there are certain care exclusions to those care home regulations, and in the employment context, the probably most important one is those who can't be vaccinated for clinical reasons. Now, when the government did that, originally employees were self-certifying that they couldn't be vaccinated for clinical reasons, but now that has to be sort of supported by medical evidence. So it's not something that employees can easily provide unless there is a clinical reason for doing so, and they can evidence that. Now, I'm not going to get into a debate about the rights and wrongs of whether people should be vaccinated within a care home setting or not, and that's perhaps for another webinar. But actually, as an employment lawyer, what I was really interested in, and one of the first questions I kind of thought about within the consultation was, what happens to employees who don't, for whatever reason, wish to be vaccinated? And that could be because they've got clinical reasons but just can't evidence it, or perhaps have more kind of philosophical reasons as to why they don't want to be vaccinated. Well, certainly the government was talking about redeployment, and certainly was emphasising redeployment as an option, but also made it clear that ultimately employees who couldn't satisfy that mandatory vaccination requirement in a care home setting were at risk of dismissal. And I think for many care homes, redeployment is always going to be a struggle for them, because they don't have a vast number of vacancies outside that kind of frontline care environment that they could easily offer to people where they didn't have to be vaccinated. So dismissal is going to be a huge issue in those cases. And I think I was reading an article today in The Guardian, actually, where it was talking about the care sector thinking that this change could result in 50,000 employees leaving the care profession, which, based on ratios of care, could impact the quality of care. I think they said of 30,000 people, but it could well be more than that. And so what we're starting to see here, isn't it, is the impact of that compulsory vaccination in terms of, you know, employee levels. That's going to be amplified, isn't it, by the announcements made yesterday, and we're starting to see the fallout from it today, that the government is now going to make vaccination a condition of deployment in the healthcare and wider social care setting, at least amongst those who have face-to-face contact with patients. Now, I think the interesting thing in with that is who's it going to actually apply to? Because as I understand it, it could apply to anyone who has the potential to come into contact with patients, which could include people in an admin capacity as well. So I think we are going to see that having a huge impact. And again, the question is going to be asked, isn't it? Well, what happens if people aren't vaccinated? And ultimately, that could see them losing their job. And I think we've seen, you know, those struggles with staffing levels in the care sector. As I say, we're going to see those within the NHS as well. Doesn't look like that mandatory vaccination within that wider healthcare setting is going to come into force until spring of next year. but certainly we are going to start to see that come through. Will we see mandatory vaccinations outside of the healthcare and social care setting? I think it's unlikely. I would never say never with the pandemic and the impact that that can bring on employment issues, but I think it's unlikely that the government will legislate. I know some employers are actually looking at whether they just impose vaccination requirements on employees. I think if you do that, you've got to think very carefully, because I think that does raise the issue of certainly outside of the healthcare sector, it's going to raise the issue of potentially discrimination claims and unfair dismissal claims. Now, the vaccination within the care home was subject to a judicial review application, which hasn't actually been heard yet. So, you know, if that judicial review application was successful, then that could really upset the apple cart, couldn't it, in terms of the government's proposals, not just for care homes, but within the NHS and the wider social care setting as well. So wait and see for the results of that judicial review. Next slide, please, Lindsay. We did see in the summer, and it was somewhat lost a little bit, I thought, in terms of the proposals, was there's going to be a review and an increase in protection to prevent sexual harassment in the workplace. Now, this follows actually is a response to a consultation that was launched in July 2019, which follows a report in December 2018, largely driven by the Me Too campaign, where I think at that stage, employers perhaps had become a little bit complacent and may have thought that actually sexual harassment was no longer a real issue in the workplace. Well, the horrendous stories that we saw out of the Me Too campaign certainly, I think burst that bubble. And so this response from the government has been long overdue. Probably the most important aspect of it is that for the first time, we're going to see a proactive duty imposed on employers to prevent sexual harassment in the workplace. You're going to have to take all reasonable steps to prevent sexual harassment in the workplace. Scope of that duty is going to be set out in the Code of Practice, which will be drawn up by the Equality and Human Rights Commission. They're also going to be responsible for enforcing it, along with individuals who no doubt can bring claims that employers haven't followed this proactive duty. It's going to be introduced as soon as parliamentary time allows. Now, actually, you may think that's suitably vague, but when you see me talk about some of the other changes, actually, as soon as parliamentary time allows is about as quick as any employment law change is likely to be made, certainly in the one that I'm going to talk about today. What will it mean for employers going forward? Well, it means you're going to need to revisit how you approach sexual harassment protection in the workplace. You know, you're going to need to make sure that your policies are up to date and relevant. You're going to need to make sure that training is up to date and relevant. Also, I think one of the interesting things that was talked about in the consultation response is that employers, I think, are going to be under pressure to actually start taking the temperature a little bit more of their workforce. I think there's an idea that perhaps senior management are out of touch with what's happening on the ground, and that actually by undertaking regular surveys of staff to ascertain how much of a problem sexual harassment is within their workplace, it will lead to more effective measures being taken to stamp that out. So as employers, I certainly think this is coming up on your horizon, and certainly, you know, just having a dusty old sexual harassment policy that really has never been revisited or people are trained on, I think is clearly not going to be enough. Next slide, please, Lindsay. The duty, sorry, can you just, sorry, yes, third-party harassment. We're also going to look at introducing protection for third-party harassment. So by way of a kind of basic example, if you as an employer run a restaurant and one of your waiting staff was subject to sexual harassment from a customer, that employee, that member of the waiting team could bring a sexual harassment claim against you, the employer, because you failed to prevent that third-party harassment. Now, that protection actually was in place previously. It was abolished in this kind of bonfire of employment law in 2013. And we're still waiting to see what the form of protection will be. Certainly there'll be a reasonable steps defence put in place. And you know, that will clearly be of interest to employers. But I think certainly employers, if you've got a customer facing employees, you're going to be looking at third-party harassment very carefully, just to see and what steps you need to take. In terms of when that's going to be introduced, well, the government says when parliamentary time allows. So I don't think this change is imminent, but I certainly think employers need to start thinking about protections from third-party harassment in order to make sure they're up to speed by the time the legislation is brought into play. Next slide, please, Lindsay. We're also probably the third main strand of that consultation on preventing sexual harassment in the workplace is extending time limits to bring claims. There's a thought that the current 3-month time limit to bring a sexual harassment claim is an impediment to employees to bring claims, and actually that should be extended to 6 months. And if they extend that to 6 months, then I think it's likely that all claims under the Equality Act, so direct disability discrimination, would also be extended to 6 months. I don't think they'll just reserve that for sexual harassment claims. Now, again, in terms of timescales, and you can see the varying approaches that we've had, the government just says it's closely looking at the extension. Well, I'm not sure how closely it needs to look at this, because effectively this would probably be one of the easiest changes to make. Changing timescales for bringing claims is relatively straightforward in terms of the legislation that you need. So again, I think if I was ranking the changes that we're likely to see, I think it's the proactive duty on employers to prevent sexual harassment that will hit the statute book first before any of these other changes, but certainly worth being aware of. Next slide, please, Lindsay. Tipping, I appreciate that not relevant necessarily to all employers, but I think is interesting to those who do certainly have tipping within their business. And the government has responded, I think, to some real horror stories about some employers who've been keeping their employees tips, and they're going to make it a requirement for all employers not to make deductions from tips received by staff other than, of course, for tax. And this will mean employers will be required to distribute tips in a fair and transparent way, and also allow employees to request information on an employee tipping record. And again, in terms of timescales for this, you'll see that dreaded phrase, it will be brought forward when parliamentary time allows. And clearly there's an awful lot of parliamentary time that's going to need to be allowed for employment law matters. So in terms of a date when this is actually going to come into force, we're still waiting for that to be confirmed. Next slide, please, Lindsay. And this new carers leave right that was introduced, and I think although it was introduced at the same time, or was talked about at the same time as the changes to flexible working, and I think got a little bit lost on the back of that. And what we're talking about here is a new right for up to 1 week, and that's 5 working days of unpaid leave per year. It's a day one right. And as with all of these things, I think the aim of it is laudable. I think it will, certainly there are some rogue employers out there who need legislation to deal with these matters. But I suspect that many people on this webinar are probably looking at this and thinking they already go above and beyond this. And actually, I would just question as to what the practical impact will be on a large level. If you look at the conditions, they're quite stringent. So it's care for a spouse, partner, civil partner, child, parent, person who lives in the same household, or someone who relies on an employee for care. Now, individuals being cared for must have a long-term care need, but I was pleased to see within the regulations that the government's avoided any sort of interrogation of individuals or the people they're caring for as to whether it's a long-term care need, as employees are going to be able to self-certify eligibility. And I know that always brings concerns for employers, that will that lead to kind of widespread misuse of this sort of legislation? And that's not my experience at all. Yes, of course, there'll be a few rogue employees out who perhaps look to take advantage of this in circumstances where they're not strictly entitled to. But, I suspect my advice isn't going to be, my employer clients aren't going to be ringing me up on a regular basis asking about that. Unsurprisingly, leave is for providing care or making provision for care. Next slide, please, Lindsay. But when we actually look at it, and obviously you can take leave in individual days or half days up to a block of 1 week. But what I thought was quite odd is that employees are required to give notice of leave, and that's twice the length of leave being requested plus 1 day, which I think kind of removes that kind of emergency leave. That will be left very much for the time off to dependents regulations. So I query the notice and whether that will actually mean there'll be an uptake. And also, employers can't deny the request for leave, but it can be postponed if an employer considers business will be unduly disrupted. So again, if an employee has an urgent request for, to look after a carer, never mind the fact that it's going to be unpaid, if they have to give notice of that and an employer can effectively postpone when they take that leave, then I'm not sure how impactful this is going to be. I should expect there'll be protection for employees who exercise their rights under this new leave from detriment to unfair dismissal. And again, we see our favourite phrase of today, it's going to be enforced when parliamentary time allows. So I'm not sure, again, how urgent that is on the government's agenda in terms of a change. Next slide, please, Lindsay. No change to fire and rehire. I thought I would mention this because it has been getting a lot of publicity. And what do we mean by fire and rehire to start with? Well, it's the concept of how employers introduce changes to terms and conditions of employment, because there's a number of ways in which an employer can do it. First of all, they could just impose the change unilaterally on employees. And please don't do that if you're listening. It can lead to breach of contract and constructive unfair dismissal claims. They can negotiate and consult with employees with a view to agreeing to a change. And then the third route is if that consultation doesn't result in an agreement that's acceptable to the employer, then the employer can effectively give an employee notice of termination of employment with an offer of re-engagement on the new terms at the end of the notice period. If the employee accepts that, their employment continues on the new terms with continuity preserved. If they reject it, their employment terminates and it still counts as a dismissal. Now, there's been some controversial uses of what people refer to as fire and rehire over the last few months. British Gas particularly have hit the headlines for using it to impose changes to their heating engineers, and that has been hugely controversial. ACAS published a report on fire and rehire, and whilst certainly some horror stories were highlighted, I think it's fair to say there was no consensus from the participants responding. And certainly I think there was an understanding that employers have to be in a position where, if they need to, that they can make changes to terms and conditions of employment. And certainly the government, on the back of the ACAS consultation, said they had no plans to introduce legislation to ban the use of fire and rehire, and actually went as far as blocking a private member's bill in Parliament a few weeks ago that would have had the same effect. Where I do think though will be interesting is that ACAS have been instructed to provide clearer guidance on when fire and rehire is appropriate. And I think that will be the real issue, because, as I said, if you're an employee who's faced with this situation and you don't accept re-engagement on the new term, then you're treated as being dismissed. If you've got 2 years service, that means you can bring an unfair dismissal claim. Now, that's when an employment tribunal will scrutinise whether the reason for introducing the change is a good business reason. Now, that can be fairly wide at the moment, but I think if the ACAS guidance narrows that down and really does try and restrict the use of fire and rehire tactics to only fairly extreme circumstances, we may see more unfair dismissal claims being brought as a result of this. And always important as well that employers follow a fair process before they get this stage. I always think fire and rehire is kind of the nuclear option when it comes to changing terms and conditions of employment, and not one you should use easily and without advice. Next slide, please, Lindsay. I just wanted to also mention, lastly, increase in employment costs. I know employers are feeling the squeeze, as employees are, I'm sure. National insurance contributions are going to increase from April 2022 by 1.25%. And we're also, as the budget announced, going to see an increase in national minimum wage levels from April 2022, with the headline national living wage rate for those 23 and above rising from £8.91 to £9.50. Now, I posted that on LinkedIn recently, and quite rightly, one of my connections pushed back, said, well, actually, if an employer can't afford an increase of 59 pence, then they shouldn't be in business, which I thought was quite a punchy response to my post. But I get the point, although I would slightly counter that and say, certainly within some sectors, care sector, for example, margins are incredibly tight, particularly if from a lot of it relies on being funded by local authorities in effect. And that sort of increase, I think, could have a significant impact for some employers, and may push some employers from operating on contracts that they're just about making a profit on, to being pushed into the negative. So, and not one to be overlooked, and definitely one to start factoring in terms of employment costs. So hopefully that gives you an idea of kind of what's on the horizon. As I say, probably flexible working is the biggest change that we're looking at, and then the changes to protections for sexual harassment in the workplace. Next slide, please, Lindsay. Hopefully that's been an interesting session. We've enjoyed delivering it as always. As I say, we're going to send out a recording link afterwards, and we'll send the slides out as well. I did see a couple of questions come in, and I think one of those questions was around, Lindsay, the Gibson and Lothian case, about how far does an employer's duty extend to the employee's vulnerable father rather than the employee. And my take on the Gibson case is that it was very much focused on the employer's duties to the employees rather than their kind of vulnerable relatives, which resulted in the employee not wanting to come into work. Was that your take on the case as well?
Yeah, that's exactly what I was going to say. I think that was from Louisa, wasn't it? I just typed a quick response, so we try and answer it at the end. Yeah, the point about that case was that it's the employee's perception and the employee's reasonable belief in serious or imminent danger in the workplace, and it was reasonable for Mr. Gibson to have felt that serious and imminent danger in that case because of the lack of PPE and the lack of a COVID-safe workplace where he worked. So it was his belief in that. His own reasons for worrying about it was because he had a vulnerable father at home, but ultimately it was his reasonable belief that there was that risk in the workplace. So that's what that was all about. I'm not sure if there could be disability discrimination considerations as a sort of knock-on for that, but yeah, not.
I think you'd be looking perhaps at a quite imaginative, maybe associative disability discrimination claim, which, you know, are quite technically difficult to run, although we talked about a case that was successful. But I think that would be probably the extent to which the kind of the person who needed caring for's views would be taken into account. And also had a question from another attendee about flexible working, and they asked, and it's a really good question, is office or workplace culture and cohesive team working good enough reason to disallow a continuation of remote working, or would further written reasons need to be given for this? And I think in the context of flexible working requests, so if an employee made a flexible working request and you turned that down and said, well, no, we need you in the office because of office or workplace culture and cohesive team working, then technically that would be a good, I think, objective business reason. But I think you're going to have to do more than just simply say office or workplace culture. I think that sort of just kind of very neutral comment is the type of thing, when you look at the estate agent case, is the type of thing that Employment Tribunal will latch onto. It doesn't mean that you can't do it, but I think you're going to need to dive into that and say what you mean by office and workplace culture and why you think people need to be in the office to help build that culture. Now, it may be that that's something you can easily answer, but I think you're going to need to do far more. And I think I've seen some potential sort of I think it could just be a lazy reason just to say office and workplace culture without actually explaining a little bit more around what that means for your organisation. Excellent. Well, thank you for those people who asked the questions. As I say, we've really enjoyed the session, finishing 10 minutes early. So hopefully, you know, we're on time at least. We really enjoy putting these sessions together. We'll probably be looking at doing another one March, April time, which is always a traditional area for employment law change. If there's particular topics or particular questions that you've got, our contact details are on the screen. Please do let us know. We're on LinkedIn. Subscribe to the Moorcrofts Means Business podcast, because we always have lots of interesting comments on there about employment law. So thank you very much for joining us. We've really enjoyed the session and look forward to, well, hopefully we might get to see you at an actual physical seminar going forward, but these webinars do allow us to get through to a lot more people. So thank you for your attendance, and we'll look forward to catching up soon. Thank you.
Thank you.